Hearing touching on voting rights, governmental powers, and huge prisons, all wrapped up in one. We're going to unpack it tonight. A voter is looking to force Governor Sarah Huckabee Sanders to hold a special election earlier. It's all to fill the vacant state Senate seat in the district where the governor wants to build a 3,000-bed prison. THV 11's Catherine Rowley sat through today's court hearing and brings us the rundown. Catherine?
Well, really, people who oppose that Franklin County prison have been angry since the governor set the dates for March 3rd and June 9th. The vote would replace State Senator Gary Stubblefield, who passed away last month. He opposed the prison and helped push off decisions on whether or not to build it until next spring. Now, those dates to fill his seat mean his district won't have a say. But the judge in the lawsuit today has to figure out who has the say by law when it comes to special elections.
The discretion's simply not there. In the Constitution, it says she shall issue a writ of election. It doesn't say she can pick the dates. It doesn't say she can put it out as far as she wants.
That's attorney Jennifer Standiford, the lawyer for Colt Shelby. She's pointing to the state law that tries to spell out the process when a member of the legislature dies in office. Arkansas Code says that a governor should act quickly within at least 150 days unless holding a special election is, quote, impractical or burdensome. To those opposed to the Franklin County prison, the governor is taking those exceptions way too far.
150 days is 150 days, and with no good reason, trying to say it saves $20,000, that's $5,000 per county if you really want to look at it. It's really ridiculous. I mean, to even go out 14 months originally and not have representation, it's just stealing representation from those people. State
Senator Brian King says regardless of how he feels about the prison, leaving his colleague's seat open through the next year's fiscal session just isn't right.
In reality, what is being transpired, the real reason is about impacting the budget session, billions of dollars. These, won't have representation on education issues, any issue at all.
Shelby's lawsuit points out that the timeline the governor set out doesn't match other more recent vacancies, including during Republican administrations.
And let's get it up there under 150, just like Asa Hutchinson did it. I looked at the time frame. I looked up the Lance Eads, which was in 2021. If Lance Eads and Asa Hutchinson could make this happen and get representation for District 7, I don't see why District 26 can't get the same.
Attorney General Tim Griffin is defending the timeline, saying Shelby's case should be dismissed. They say that the law does give the governor discretion if she thinks holding a small election weeks before a bigger one is too expensive. But Shelby and Standiford argue the timeline right now violates fundamental voting rights.
And the reason is, this is something that's in the Constitution. It's for the people. We are the voice. This is Arkansas. This isn't Washington, D.C. We don't have a communist state. It's democracy.
Asking for is just for the court to enforce the law, just for the court to consider the constitutional rights of the voters, to consider that the law itself requires that these be expedited and moved up.
Now, Judge Patricia James did not make a ruling today despite Shelby's calls to expedite the case. Among the witnesses who testified today were local election officials who say that they could get an entire special election wrapped up before April. But the clock is ticking on that. And one more thing to add, a special election is set for the same dates to fill the vacancy in House District 70 here in North Little Rock and Sherwood.